Welcome once again to Kairu Know Your Rights University. In the name of Allah the Beneficent, the Merciful, we bear witness that there is no God but Allah and that Muhammad is his messenger. Assalamu alaikum. Welcoming you once again to Kairu, our listening audience, where we hope to share with you some educational information and we hope that it will be of some benefit to you and your loved ones. Let us begin. It's coming from a doctrine rather called fraud or constructive fraud, breach of fiduciary duty, and conflict of interest. In order to constitute in order to constitute fraud in the inducement, the defendant must have made a false representation of a material fact, knowing or believing it to be false and doing it for the purpose of inducing the plaintiff to act. Fraud also may consist of the intentional omission or concealment of a material fact under circumstances creating an opportunity and duty to speak. In order to prove fraud by the intentional concealment of a material fact, it is necessary to show the existence of a special or fiduciary relationship which would raise a duty to speak. Significantly, in a confidential or fiduciary relationship, the dominant party's silence alone may constitute fraudulent concealment. It is well settled that a fiduciary relationship exists between trustee and beneficiary as a matter of law. Under the Fiduciary Obligations Act, a fiduciary includes a trustee under any trust. The Act further specifies that, in any case not provided for in this Act, the rules of law and equity, including the law merchant and those rules of law and equity relating to trust, agency, negotiable instruments, and banking, shall continue to apply. The relationship between trustee and beneficiary is such that the duties rest upon the trustee to serve the interests of the beneficiary with complete loyalty, excluding all self-interest. Prevailing authorities hold that a release between a trustee and a beneficiary, like all transactions growing out of a fiduciary relationship, is subject to the closest scrutiny. Fiduciaries are not prohibited from having direct dealings with their beneficiaries, but such transactions are subject to special scrutiny by the courts, and the burden is on the fiduciary to show that the transaction was fair. In Collins, the court held that important factors in determining whether a particular transaction is fair include a showing by the fiduciary that he has made a free and frank disclosure of all the relevant information which he had, that the consideration was adequate, and that the principal had competent and independent advice before completing the transaction. Additionally, we note the well-established principle that a trustee cannot simply delegate his own duty to provide information to his beneficiary or force the beneficiary to find other avenues for information he is rightfully owed. The law does not contemplate that a beneficiary of a trust must set in motion the process of a court in order to obtain what he is entitled to. As long as the long established high duties of a trustee were explained by the court in re the trusteeship under the last will and testament of Hartzell, quoting, although purely ministerial powers or duties may be delegated by a trustee, generally a trustee may not delegate powers and duties involving an exercise of judgment and discretion. A trustee must use care and diligence in the discharge of his powers and duties. He is held to a high standard of conduct and must exercise the utmost or highest good faith in the administration of the trust. Adherence to fundamental principles dictates that a trustee is held to a high standard of conduct and must exercise the utmost or highest good faith in the administration of the trust, and that acting with good faith in administering the trust means that the trustee must act honestly and with undivided loyalty to the trust. not merely with the standard of the workday world, but with the most sensitive degree of honor. Thus, under our de novo review, we cannot find any superseding proximate cause as a matter of law sufficient to dismiss plaintiff's cause of action. The Corporate Opportunity Doctrine. The Corporate Opportunity Doctrine provides that corporate fiduciaries and employees cannot, without consent, divert and exploit for their own benefit any opportunity that should be deemed an asset of the corporation. In this context, a corporate opportunity is defined as any property, information, or prospective business dealing in which the corporation has an interest or a tangible expectancy, or which is essential to its existence or logically and naturally adaptable to its business. Such an interest or tangible expectancy constitutes something much less tenable than ownership, but on the other hand, more certain than a desire or a hope. The Second Circuit has held that the existence of a tangible expectancy depends on degree of likelihood that the corporation will realize that opportunity. The purpose of this doctrine is to prevent employees from acquiring property which the corporation needs or is seeking, or which they are otherwise under a duty to the corporation to acquire for it. To remedy a usurped corporate opportunity, a court may impress a constructive trust in favor of the corporation upon the property acquired. The value of the diverted asset is the amount plaintiff would have received but for the defendant's wrongful interference, including opportunities for profit on the accounts diverted from it through defendant's conduct. The faithless servant doctrine. An employee must be loyal to his employer and is prohibited from acting in any manner inconsistent with his agency or trust, and is at all times bound to exercise the utmost good faith and loyalty in the performance of his duties. The faithless servant doctrine, which is grounded in the law of agency, provides relief to an employer whose employee has engaged in repeated acts of disloyal conduct during the course of his or her employment. The New York Court of Appeals has indicated that the faithless servant doctrine applies to disloyal trustees as well. In Murray versus Beard, the Court of Appeals instructed that an agent is held to umberima fides, utmost fidelity, in his dealings with his principal, and if he acts adversely to his employer in any part of the transaction, or omits to disclose any interest which would naturally influence his conduct in dealing with the subject of the employment, it amounts to such a fraud upon the principal as to forfeit any right to compensation for services. Thus, if an employee or trustee is shown repeatedly to have been disloyal throughout his or her tenure, complete and permanent forfeiture of compensation, deferred or otherwise, is warranted. Complete forfeiture of compensation is proper even when some or all of the agent's services were beneficial to the principal, or when the principal suffered no provable damage as a result of the breach of fidelity by the agent. This is because the purpose of a breach of fiduciary claim, unlike an ordinary tort or contract case, is not merely to compensate the plaintiff for wrongs committed by the defendant, but to prevent them by removing from agents and trustees all inducement to attempt dealing for their own benefit in matters which they have undertaken for others, or to which their agency or trust relates. For example, in Fansalkar versus Anderson Weinroth and Company LP, the Second Circuit held that New York's faithless servant doctrine required that a disloyal employee forfeit all compensation received after his first disloyal act. In that case, the defendant employee was compensated generally, i.e., via a salary, and was not compensated specifically for the completion of certain tasks or transactions. In those circumstances, the circuit held that forfeiture could not appropriately be limited to only some transactions, which were affected by the employee's disloyalty. Rather, the faithless servant doctrine required that he forfeit all compensation awarded to him. Our holding is also compatible with the articulated purpose of the official misconduct and conflict of interest statutes, which is to keep the loyalties of public officials to their public trusts undivided and to compel them to act in a lawful manner while acting in their official capacities. To allow the use of public funds to reimburse a convicted official for his legal expenses would shield that official from the entire consequences of his illegal conduct, thus frustrating the purpose of those statutes. In conclusion, the city has neither the duty nor the authority to reimburse plaintiffs for legal fees incurred in the unsuccessful defense of criminal official misconduct and conflict of interest charges. Therefore, to the extent it attempts to indemnify officials convicted of crimes for their attorney's fees and costs incurred in their unsuccessful criminal defense, we hold the Danville Ordinance invalid. In so holding, we expressly make no determination regarding the authority of any municipality or home rule unit to indemnify its officers and employees who are found not guilty of criminal conduct. Plaintiffs cite Northern Trust Company versus Hewer for the proposition that a fiduciary's duty to each beneficiary precludes it from favoring one party over another. In Hewer, the trustee filed a complaint in the circuit court for construction of the trust agreement and argued that the court interpret the trust in a manner that was favorable to one beneficiary and detrimental to the other. The court found the trustee breached his duty of impartiality in that he should not have argued for an interpretation that favored one of the beneficiaries at the expense of the other. Hewer involves an instance of blatant favoritism on the part of the trustee for one beneficiary over the other. Among the proper remedies for self-dealing by a trustee is the imposition of a constructive trust on the diverted assets. One who receives property as a result of a breach of trust holds the property in constructive trust and has a duty to surrender the property. New York courts have found that constructive trusts are peculiarly suited to circumstances in which a fiduciary has been guilty of self-dealing. In such circumstances, in the words of Justice Cardozo, equity converts the holder of legal title into a trustee. A constructive trust is a flexible, equitable remedy that is intended to prevent unjust enrichment. A court asked to impose a constructive trust may consider evidence of a fiduciary relationship, a promise, reliance, and unjust enrichment. However, a constructive trust is a flexible device and must not be bound by an unyielding formula. The party seeking a constructive trust must establish the facts which require it by clear and convincing evidence. To remedy a usurped corporate opportunity, a court may impress a constructive trust in favor of the corporation upon the property acquired. The value of the diverted assets is the amount plaintiff would have received but for the defendant's wrongful interference, including opportunities for profit on the accounts diverted from it through defendant's conduct. C. Saltzman. One who receives property as a result of a breach of trust holds the property in constructive trust. In the case of a constructive trust, the duty is merely to surrender the property. Turning to the merits, Morgan Stanley argues that the shareholders have failed to state a claim. The law recognizes two types of fraud, actual and constructive. The shareholders concede that they failed to allege actual fraud. Instead, they say that they are pleading some type of constructive fraud. And they add that this kind of claim should not be subject to the heightened pleading requirements of Federal Rules of Civil Procedure 9b. Unlike actual fraud, constructive fraud requires neither actual dishonesty nor intent to deceive, being a breach of legal or equitable duty which, irrespective of the moral guilt of the wrongdoer, the law declares fraudulent because of its tendency to deceive others. Constructive fraud includes any act, statement, or omission which amounts to positive fraud or which is construed as a fraud by the courts because of its detrimental effect upon public interest and public or private confidence. This claim requires the existence of a confidential or fiduciary relationship. Indeed, a plaintiff claiming constructive fraud must show that that defendant breached the fiduciary duty he owed to plaintiff and knew of the breach and accepted the fruits of the fraud. Constructive fraud is a breach of legal or equitable duty which, without regard to moral guilt or intent of the person charged, the law declares fraudulent because the breach tends to deceive others, violates public or private confidence, or injures public interest. While it does not require a showing of intent to deceive or dishonesty of purpose, it does require a fiduciary or confidential relationship. Most importantly, for our purposes, the breach of duty by the person in the confidential or fiduciary relationship must induce justifiable reliance by the other to his detriment. 37 American Jurisprudence, second edition, Fraud and Deceit. Section 9. See also in re McDonald's estate, where it was held the difference between actual and constructive fraud is that former actual fraud requires actual intent to deceive, while other is characterized as a breach of a duty actionable irrespective of moral guilt and arising out of a confidential relationship. Walt versus Ring, it was held, breach of fiduciary duty by fraudulently concealing treatment errors told statute of limitations until concealment is discovered or reasonably should be discovered or presumably until plaintiff had actual knowledge of underlying mistreatment. Appellant's counsel argue that Smith does not hold an office as that word is defined in Section 24 of Article 5 of the Constitution. That section defines an office as a public position created by the Constitution or law, continuing during the pleasure of the appointing power or for a fixed time, with a successor elected or appointed. This court has held that this definition is one to be limited in its application as a definition to the state government with those to the state, hold on, let's read that again. This court has held that this definition is one to be limited in its application as a definition to the state government with whose executive department Article 5 of the Constitution deals. Fergus versus Russell. The same rule of distinction between office and employment laid down in Fergus versus Russell applies to local governments as well as to state government. Smith's position as treasurer is an office. It is created by statute. He is elected by the board. He holds office during the pleasure of the board. His duties and compensation are determined by it. It is also a public office, and he likewise a public officer. In the discharge of his duties, he exercises a part of the public powers of sovereignty, so far as those powers are by the statute vested in the sanitary district. Those powers are to be exercised in the public interest and for the public benefit. These contentions of appellants cannot be sustained. We are of the opinion that the record shows that Smith was interested in this contract and that the position he occupied was that of an officer who might be called upon to act in the making of that contract, as contemplated by Section 3 of the Act quoted. The contract was therefore void, and the appellate court did not err in so holding. A public office is a public trust. Borough councilmen, as fiduciaries and trustees of the public interest, must serve that interest with the highest fidelity. The law tolerates no mingling of self-interest. It demands exclusive loyalty. The theory is that a public officer assumes the same fiduciary relationship towards the citizens of his community as a trustee bears to a Sesque trust. They have the right to expect that in everything that appertains to their business or welfare, he will exercise his best judgment, unaffected and undiluted by anything which might inure to his own interests as an individual. In the case of Clive Pressey versus Township of Hillsborough, it was held the record presents a callous disregard of the most elementary principles governing the legal and moral obligations of municipal officers to the community which they have been elected to serve, as well as those dealing with them. However elementary these principles should be briefly restated. Public office is a public trust created in the interest and for the benefit of the people. Public officers stand in a fiduciary relationship to the people with whom they have been elected or appointed to serve. Public officers stand in a fiduciary relationship to the people whom they have been elected or appointed to serve. One more time. Public officers stand in a fiduciary relationship to the people whom they have been elected or appointed to serve. The specific subject was exhaustively covered, and the authorities collated in Driscoll versus Burlington Bristol Bridge Company. The following excerpt from 8 New Jersey at pages 474 and 475 of the opinion of Chief Justice Vanderbilt is particularly pertinent. As fiduciaries and trustees of the public will, they, municipal officers, are under an inescapable obligation to serve the public with the highest fidelity. In discharging the duties of their office, they are required to display such intelligence and skill as they are capable of, to be diligent and conscientious, to exercise their discretion not arbitrarily but reasonably, and above all, to display good faith, honesty, and integrity. They must be impervious to corrupting influences. They must be impervious to corrupting influences. They must be impervious to corrupting influences. When public officials do not so conduct themselves and discharge their duties, their actions are inimical to and inconsistent with the public interest. And not only are they individually deserving of censure and reproach, but the transactions which they have entered into are contrary to public policy, illegal, and should be set aside to the fullest extent possible, consistent with protecting the rights of innocent parties. These obligations are not mere theoretical concepts or idealistic abstractions of no practical force and effect. They are obligations imposed by the common law on the public officers and assumed by them as a matter of law upon their entering public office. The enforcement of these obligations is essential to the soundness and efficiency of our government, which exists for the benefit of the people who are its sovereign. The enforcement of these obligations is essential to the soundness and efficiency of our government, which exists for the benefit of the people who are its sovereigns. One more time. The enforcement of these obligations is essential to the soundness and efficiency of our government, which exists for the benefit of the people who are its sovereign. The Constitution creates three branches of government, which creates a separation of powers. Separation of powers is a doctrine of constitutional law under which the three branches of U.S. government, executive, legislative, and judicial, and their duties are kept legally separate. This is also known as a system of checks and balances, because each branch is given certain powers so as to impact and block other branches who may overstep their duties. The separation of powers doctrine divides government responsibilities into the three branches in order to prevent any one branch from taking over another's duties. The goal of the framers in their creation of separation of powers was to prevent a concentration of power by one branch and thus unequal control over the government. Each branch has separate powers, and generally each branch is not allowed to exercise the powers of the other branches. The legislative branch or Congress exercises and congressional power to create laws or states. The executive branch, led by the president, exercises executive power to enforce the laws of the legislature. Finally, the judicial branch, headed by the Supreme Court, exercises judicial review over the other two branches' actions. In the 1970 Illinois Constitution, in Article 6, Sections 13 and 14, Section 13, prohibited activities, the Supreme Court shall adopt rules of conduct for judges and associate judges. B. Judges and associate judges shall devote full time to judicial duties. They shall not practice law, hold a position of profit, hold office under the United States or this state or unit of local government or school district or in a political party. Section 14, judicial salaries and expenses. Fee officers eliminated. Judges shall receive salaries provided by law, which shall not be diminished to take effect during their terms of office. All salaries and such expenses as may be provided by law shall be paid by the state, except that appellate, circuit, and associate judges shall receive such additional compensation from counties within their districts or circuit as may be provided by law. There shall be no fee officers in the judicial system. In addition, Illinois Supreme Court Rule Canon 1, Rule 1.1 states a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety in all of the judge's activities. Rule 1.1, compliance with the law. A judge shall comply with the law, including the code. Rule 1.3, avoiding misuse of the prestige of judicial office. A judge shall not misuse the prestige of judicial office to advance the personal or economic interests of the judge or others or allow others to do so. Rule 2.4, external influences on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. A judge shall not permit family, social, political, financial, or other interests of relationships to influence the judge's judicial conduct or judgment. A judge shall not convey or permit others to convey the impression that any person or organization is in a position to influence the judge. Comments. 1. An independent judiciary requires that judges decide cases according to the law and facts without regard to whether particular law or litigants Comments. 1. An independent judiciary requires that judges decide cases according to the law and facts without regard to whether particular laws or litigants are popular or unpopular with the public, the media, government officials, or the judge's friends or family. Confidence in the judiciary is eroded if judicial decision-making is perceived to be subject to inappropriate outside influences. Confidence in the judiciary is eroded if judicial decision-making is perceived to be subject to inappropriate outside influences. One more time. Confidence in the judiciary is eroded if judicial decision-making is perceived to be subject to inappropriate outside influences. Rule 2.11, disqualification. A judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. 1. The judge has a personal bias or prejudice concerning a party or a party's lawyer or personal knowledge of facts that are in dispute in proceeding. 2. The judge knows that the judge's spouse or domestic partner, a person within the third degree of relationship to either of them, or the spouse or domestic partner of such a person, is a party to the proceeding, or an officer, director, general partner, managing member, or trustee of a party. B. Acting as a lawyer in the proceeding. C. A person who is more than a de minimis interest that could be substantially affected by the proceeding or likely to be a material witness in the proceeding. 3. The judge knowingly, individually, or as a fiduciary, or the judge's spouse, domestic partner, parent, or child, wherever residing, or any other member of the judge's family residing in the judge's household, has an economic interest in the subject matter in controversy or is a party to the proceedings. Comments. 6. Economic interest, as set forth in the terminology section, means ownership of more than a de minimis legal or equitable interest, except for situations in which a judge participates in the management of such a legal or equitable interest, or the interest could be substantially affected by the outcome of a proceeding before a judge. Rule 3.15, reporting requirements. A judge shall file annually with the clerk of the Illinois Supreme Court a verified written statement of economic interest. The conflicts of interest, the contents of and filing deadline for the statement shall be as specified by administrative order of this court. Comments. 1. The statement of economic interest required by this rule is intended to maintain and promote public confidence in the integrity, impartiality, fairness, and independence of the judiciary, provide public information bearing on judges, potential conflict of interest, and foster compliance with the code. The statement is designed to achieve an appropriate balance with respect to particular information that might reasonably bear on these objectives between the value of public disclosure of that information on the one hand and judges' legitimate privacy interests on the other hand. Administrative order. 1. The verified written statement of economic interest referred to in Rule 3.15 shall be filed annually by all judges on or before April 30th. Statements also shall be filed by every person who becomes a judge within 45 days after assuming office. However, judges who assume office on or after December 1st and who file their statement before the following April 30th shall not be required to file another statement until the next year. Impartial means in part the absence of bias or prejudice in favor of or against particular parties or classes of parties. A judge must recuse himself or herself from a case if the judge's impartiality might reasonably be questioned, and which can occur even in the absence of an enumerated circumstances. Indeed, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of A1 through 6 apply. In the Franklin versus McCarthy case, it was held, applying State versus Rochelle. The court first held that Judge Schrader's statement that he was not biased against Franklin was sufficient to show that he was subjectively biased. The Due Process Clause guarantees litigants an impartial judge, reflecting the principle that no man is permitted to try cases where he has an interest in the outcome, where the judge has a direct personal substitute for pecuniary interests. Due process is violated. The Due Process Clause guarantees litigants an impartial judge, reflecting the principle that no man is permitted to try cases where he has an interest in the outcome. Where the judge has a direct personal, substantial, or pecuniary interest, due process is violated. One more time. The Due Process Clause guarantees litigants an impartial judge, reflecting the principles that no man is permitted to try cases where he has an interest in the outcome. Where the judge has a direct personal, where the judge has a direct, personal, substantial, or pecuniary interest, due process is violated. The general presumption is that judges are honest, upright individuals, and thus that they rise above biasing influences. A person could find something in the background of most judges which, in many cases, would lead that person to conclude that the judge has a possible temptation to be biased, but not all temptations are created equal. Nevertheless, the presumption is rebuttable. Sometimes the influence is so strong that we may presume actual bias. In rare cases, there may even be evidence of actual bias. To prove this qualifying bias, a petitioner must offer either direct evidence or a possible temptation to sever, excuse me, or a possible temptation so severe that we might presume an actual substantial incentive to be biased. Absent a smoking gun, a petitioner may rely on circumstantial evidence to prove the necessary bias. As, as noted above, the Wisconsin Court of Appeals limited its analysis to an assessment of his claim under its own decision in Rochelle. Rochelle sets forth a two-part test to determine whether a defendant's due process right to an impartial judge has been violated. The first, a subjective inquiry, is based on the judge's own determination of his or her impartiality. The second, an objective examination, asks whether a reasonable person could question the judge's impartiality. If after the objective inquiry the judge's impartiality appears questionable, Rochelle instructs courts to perform a harmless error analysis. The Rochelle decision has little to say about federal law. It acknowledges Aetna Life Insurance Company versus Lavoie, holding that a state Supreme Court justice's participation in a case violated the appellant's due process rights where the justice had a direct, personal, substantial, and pecuniary interest in the case. Let's say that again. Holding that a state Supreme Court justice's participation in a case violated the appellant's due process rights where the justice had a direct, personal, substantial, and pecuniary interest in the case. One more time. Holding that a state Supreme Court justice's participation in a case violated the appellant's due process rights where the justice had a direct, personal, substantial, and pecuniary interest in the case. In a footnote, but it did not specifically discuss Aetna Life or any other U.S. Supreme Court case in analyzing Rochelle's claim. Limiting the inquiry into judicial bias to the Rochelle test was inconsistent with the governing decisions of the U.S. Supreme Court. Both components of Rochelle look only for bias that resulted in demonstrable prejudice to the defendant. A litigant is denied due process only if the judge in fact treats him or her unfairly. After applying the two components of the court finds evidence of actual partiality, it then applies a harmless error analysis. Even though the trial judge's letter raises a reasonable question regarding the judge's impartiality, the fact is that Rochelle received a fair trial and therefore the judge's refusal to recuse himself was harmless error. We conclude that the Rochelle analysis is contrary to clearly established federal law for two reasons. First, as Judge Evans of this court observed in his opinion for two different majorities of this court in Bracey versus Schomeg, the Supreme Court has decided that both actual bias and the appearance of bias violate due process principles. See Bracey. Actual bias, Toomey. Actual pecuniary interest, and thus actual bias, Aetna. The due process clause may sometimes bar trial by judges who have no actual basis and who would do their very best to weigh the scales of justice equally between contending parties. Second, where there is a structural error, such as judicial bias, a harmless error analysis is irrelevant because Judge Schrader was actually biased. Franklin is entitled to a new trial. Accordingly, we vacate and remand this case with instructions to grant Franklin's petition for habeas corpus unless the state institutes proceedings to retry him within 60 days. And this concludes our video for today. We thank you once again for listening, and we hope that this information has been informative and educational and turns out to be of some benefit to you, so you and we may be able to protect our rights and to never allow anyone to infringe upon those rights. Thank you once again for listening. We greet you in the greeting words of peace. Assalamu alaikum. And until next time, God's be.